If you've been on social media and in the world of artificial intelligence creativity, then you definitely know what this image is. This is an image that has been at the center of controversy, an image that was created by an artificial intelligence tool. But why is it so important? Well, welcome to Death Blow or Dead Wrong, the Thaler versus Perlmutter ruling explained. What the viral narratives got right and what they got catastrophically wrong, and what it actually means for creators worldwide. You see, the image that I showed you was created by an AI machine that was created by the inventor, the scientist, the computer scientist, Stephen Thaler. Why does it matter? It matters because people have been citing what happened to Thaler. They don't understand that Thaler, the creator of the AI machine, was actually trying to do something totally different than what they may have been trying to do. You see, Thaler put this image forth to provoke thought, not to win by saying, well, something created by AI was copywritten. No. He has been working in this field for a very long time on something called a machine creativity and computational neural system for a long time, even before GPT, before Suno. And he founded Imagination Machines, incorporated and built an AI system which he named DABUS, which just means Device for the Autonomous Bootstrapping of Unified Sentience. The name alone tells you how ambitious his thinking was. He designed it to generate novel associations by allowing artificial intelligence tools to interact in unusual ways, by producing outputs which he believed could not be traced back to any single human instruction. And around 2018 to 2019, he first filed patent applications in the US and the UK and other jurisdictions for 2 inventions that his DABUS systems generated. And here is a critical detail that most people miss. He deliberately did not list himself as the inventor. He listed DABUS as the inventor. He could have listed himself. He chose not to because his goal was not to own the patent. His goal was to force legal systems to answer a question that they had never faced. If a machine independently originates an invention, can the machine be named inventor? That was a philosophical and legal stress test, not a conventional IP claim. Thaler was acting as much like a legal philosopher as a patent applicant. He was ahead of the curve, asking questions in 2018 that the entire world was still wrestling with in 2026. You see, his inventions were not chosen randomly. They were selected specifically because they were concrete, testable, and novel enough to qualify on the merits. The only question was who invented them. And as you can see here on the screen, I have the fractal beverage container and the flashing emergency beacon. But let's fast forward to what he did in 2026. He didn't file a patent case. At the end of the day, he went into the copyright domain, right? And patent law says who conceived the invention. That's what it thrives on. The law asks who had the original idea. Well, the copyright law asks the question, who authored the expressive work? You see that word, who? It refers to a human. So let's get it straight. The Supreme Court refuses this case, not because it's not a good painting. It's because the creator is attributed to a machine, not a human, to an AI. So Thaler was emboldened by his patent battles, and he decided to experiment with visual art and copyright law. And in 2018, he submitted a copyright application for an AI-generated image, which I just showed you, right? The image was created by his creativity machine AI system. Can you imagine? Way back then, he was ahead of the curve for sure. He explicitly stated in the application the work was autonomously created by a computer algorithm. He listed the AI as the author. Now you know why it would not make sense to think this is a sign that you are in danger because your work created with Suno is going to be struck down by the courts. Don't be ridiculous. You see, without going too much further into the case, I want to get to the crux of the matter for you creatives in the world of AI. People citing this case and saying, well, I guess I should pack up shop and go home. It means that all I've been doing in AI is going to be rejected by the courts. Look, my friend, you have many components to music and many components to art. In this case, the components that was missing, the human in the loop, was not present deliberately at all. So for people to cite this case as a reason why music that they create with AI is going to be struck down in courts is a fallacy. You see how foolish it is to think that you can compare the Thaler case to people who are using Suno to amplify their ideas, to drive their ideas. You see? So what Thaler argued is the AI created this independently. I am merely its owner. The machine should be recognized as the author. If Thaler had listed his name as the author or the creator, of course, nobody would have argued to the extent he would have been checked. Is this truly his? And the copyright clause wouldn't have been problematic. But you see, what most creators do is they directed the AI. They say, I directed it, I prompted, I selected, I revised, I arranged, I edited, and I am the human author who used it as a tool. It's very different. You see, the DC Circuit Court itself drew the line explicitly. The rule requires only that the author be a human being, the person who created, operated, or used artificial intelligence. Thaler lost because he removed that human. You are not Thaler. If you are prompting, iterating, curating, arranging, and making creative decisions, not to mention going into your DAW and doing all this mixing and mastering stuff and adding tracks. Look, I think I've made my case very clear that you are not Thaler. You're not trying to achieve the same thing. Thaler is deliberately going against the grain to provoke thought, and kudos to him and thumbs up to him. He's asking very good questions. At the end of the day, is it the creator of the machine that gets attributed the copyright, or is it the machine itself? You see? So what actually happened, if you look at the chronology here, he filed a copyright application, he repeated the claim, and he kept being rejected by the Copyright Office. And then 2023, the DC District Court affirms rejection. And then in 2025, he took it up a notch again. DC Circuit Appeals Court affirms again. And then he went all the way up to the top in 2026. Supreme Court denies, finally. They denied to hear the case without comment or ruling on the merits. And this leaves the DC Circuit ruling intact, but it does not constitute a Supreme Court ruling on AI copyright broadly. The door remains open for future cases. So when people take a look at this case and they say, oh, well, I guess woe is us. Woe is me because I used Suno and this guy used an AI to create something and the Supreme Court said he's not the owner. No, that didn't happen. What he was trying to achieve was not ownership for himself. He was trying to achieve ownership for his AI machines and really just to push the boundaries of courts of law. And I think he's doing a really great job. These things need to be discussed. We cannot escape them. I hope this makes sense. If you have any questions or comments, drop me one below, but let's make it very clear. There is a difference between you, the creative, versus Thaler. Thaler is not looking for accolades. He's not looking for copyright for himself. He's looking for copyright for his AI machine. It's like for you saying, oh, I want to give Suno the copyright. Well, that would be the case if Suno did everything. But you also need to remember the argument here. Even when you just hit a button in Suno that says create, you are a human in the loop because you're also specifying what you want it to create. So let's not get it twisted. Let's not blow this out of proportion. There's a lot of sensationalism going on. People just making up ridiculous stories about this case and saying, well, that means those people who use AI for music are doomed. It's all for clicks. This is the video that you want to pay attention to. Thank you, my friends. Talk to you again soon. Bye for now.